everyone, and welcome to today's MnDHR Workforce Webinar Series, Beyond Ban the Box, Hiring People with Criminal Backgrounds. For today's webinar, the audio will be muted for participants. You will find the chat feature to ask questions. Please type your questions into the chat box. We will hold these questions until the end of the presentation. We have two presenters today, Commissioner Kevin Lindsey and Emily Baxter from We Are All Criminals. Kevin Lindsey was appointed Commissioner of Minnesota Department of Human Rights in February 2011. He had previously served as a civil litigation attorney in the office of the Ramsey County Attorney and has over 25 years of experience in resolving complex legal and public policy questions. Emily Baxter is the Executive Director of We Are All Criminals, a media-based advocacy project and organization. Prior to this, Emily served as the Director of Advocacy and Public Policy at the Council on Crime and Justice and has an Assistant Public Defender and served as an Assistant Public Defender at the Regional Native Public Defense Corporation, representing indigent members of the Leech Lake and White Earth Band of Ojibwe, charged with crimes in the Minnesota State Court. Emily is the former fellow at the University of Minnesota Law School's Robina Institute of Criminal Law and Criminal Justice. Emily began developing We Are All Criminals through an Archibald Bush Leadership Fellowship in 2012. Please welcome Emily Baxter.
Thank you so much for that, and thank you to everyone for tuning in. All right, shall we get started? Have you ever been convicted of an offense? Yes or no? That's the question that had been weighing upon Anthony's mind as he hovered in the back of a government center's basement room some 6 years ago. Yes, he would have to check on his job application, the last 13 to be exact. Yes, on his rental application. Yes, on his college application. Yes, on his loan application. Yes, yes, yes. What would you check? Have you ever been convicted of an offense? Perhaps like me, you could say no. If, however, like Anthony, you said yes, know that you are one of the estimated 65 to 100 million people in the United States with a criminal record. Let me tell you how I met Anthony. Several years ago, I left my job in public defense to work in public policy. I thought that if I could change the laws that were so acutely affecting my clients, I could be a better advocate. I took a job at a legal nonprofit in Minneapolis, the Council on Crime and Justice, and my focus was on criminal records. We held expungement clinics in the basement of the Hennepin County Government Center in a small, windowless, utterly depressing room. In this space, men, women, and youth, all poor, predominantly people of color, would wait for hours to speak with an attorney, someone who could, in theory, help them wipe that slate clean. I'm sure the sun had long since set one night when in walked our last participant. Anthony was tall, thin, black, and clearly distraught. He walked hesitantly toward me, and as he sat across the table from me, he pulled from his back pocket a copy of his criminal record, a printout he had received from a computer terminal 2 flights up. Given this man's clear distress, I nervously opened it. What could his record contain that would warrant this worry? What could possibly cause this much stress? You may imagine my surprise when I opened it to find that it contained no more than a theft, and a minor one at that. I let out a short laugh of relief. Even if the court doesn't expunge the record, I said, it's not like your life is over. And with that, Anthony started to cry. He told me that earlier that day, he'd considered taking his own life. You see, while it was just a theft to me, to Anthony it was a lost job. It was missed housing payments. It was skipped meals. It was door after door slammed in his face. It was the loss of respect from his friends and family, the loss of a sense of self, the loss of hope. Around the same time, I've been driving all across the state of Minnesota, reaching out to employers and landlords, legislators and licensing boards, asking them to create the capacity for second chances. Time and again, I would hear, you can't trust a con. Once a criminal, always a criminal. Those words came back to me as I looked at Anthony, and I thought, hold up, how many times had I taken something that wasn't mine? Sure, I'd considered my own criminality before, but not like this. I hadn't really thought about what life would be like living in the shadow of having been caught, under the suffocating stigma of a criminal record. What would life be like for me if I didn't have the luxury to forget? 1 in 4 people in the United States doesn't have the luxury to wonder. 1 in 4 people in the United States has a criminal record. I contend that 4 in 4 have a criminal history. For the past few years, I've been asking people like me, the 75% of people in the United States with criminal histories but no record, what have you had the luxury to forget? Today, I want to share with you just some of those stories. I'm going to focus mostly on crimes committed before participants' brains were fully developed, although understand that that is just the tip of the iceberg. This is just the beginning of the conversation. Now, some of these stories are going to be petty, some will be serious. Some happened decades ago, others a bit more recently. In doing so, I hope to offer a personal way of examining the true effects of our juvenile and criminal justice systems and the disparate impact of those systems upon poor people, people of color, and indigenous people across the state and across the United States. This is going to be a call for reason, for equity, and for mercy. This is going to be about seeing, about how you see others by how you view yourself. But first, I want to make sure we're all on the same page. This is a graph with data taken from the Bureau of Justice Statistics and put together by the Sentencing Project, and it shows the U.S. state and federal prison population from 1925 through 2015. Now, barring for some general population growth, you can see that the number of people we put behind bars in the United States was pretty much steady until the 1970s. Then, more than 4 decades ago, we began the deliberate and regrettable march toward this, the caging of nearly 1.5 million people. Wars on drugs, mental illness, and poverty, private prisons, 3 strikes rules, and mandatory minimum sentencing, as well as concentrated policing in minority communities are just a few of the many policies and practices that have led to this mass incarceration mass disaster. Note that while mass incarceration is not only unprecedented in our own history, it is unparalleled in the world. The United States holds about 5% of the world's general population, but nearly 25% of the world's incarcerated population. We have become the world's warden. Now, what's additionally concerning is what happens to people once they're no longer in the system, when they're back in the community just trying to get on with life. That's when a new form of punishment begins, a sentence that does not end. When people find that they may no longer be locked up, but are now locked out of jobs, housing, school, and countless opportunities to move on and move up. But before we delve into the world of collateral consequences or those lifelong effects of a criminal record, let's take a closer look at this graph. Now, as I said, and as you can see, it shows the U.S. state and federal prison population. But just as importantly is what it doesn't show. This graph doesn't show the millions of people in county and parish jails, on civil commitment and immigration holds, and in juvenile detention. It doesn't show the millions of people on probation and parole, their liberties curtailed, held under the thumb of the criminal justice system, just not spending their nights behind bars. They are not shown here on this graph. And it doesn't show the estimated 65 to 100 million people, like Anthony, with a criminal record. People held underwater by that record, unable to come up for air. They are not shown here on this graph. And just as importantly, it doesn't show the nearly 3 million sons and daughters, the countless brothers and sisters, mothers and fathers, spouses and partners, and greater family and community members who can all be profoundly affected when someone is taken out of the home and then not allowed back in through a series of collateral consequences that blockade that entry. So what may initially appear to be a tsunami of humanity ready to crash upon our shores, you realize it's just a drop in the overall greater ocean of a crisis. And that crisis comes at no small cost. Every year, the U.S. spends nearly $80 billion locking people up and keeping them under control. But that doesn't include what communities spend to house, train, educate, counsel, treat, employ, and otherwise transition individuals who are leaving prison or jail. And that is a burden that is not borne equally across our country. For example, again from the Sentencing Project, the lifetime likelihood of imprisonment for black males born in 2001 is 1 in 3. 1 in 3. For white women such as myself, it's 1 in 111. Now that's not to say that white women aren't committing crimes, right? But we're not who you see, proportionately speaking, in the criminal justice system. Importantly, note that rates of offending do not come close to explaining these disparities. Looking at just the war on drugs, arguably one of the greatest contributing factors to our current carceral crisis, white and black individuals use and sell drugs at roughly the same rates, yet black individuals are far more likely to be stopped, searched, arrested, charged, prosecuted, convicted, and then punished and further punished again through that series of collateral consequences than are white individuals for engaging in the same behavior. Now, in addition to people of color, our system disparately affects individuals with mental health and chemical dependency concerns, and it profoundly affects poor people. For example, there are more than 12 million arrests made each year in this nation. 80% of those arrested qualify for public defense. In many jurisdictions across the nation, in order to be eligible for free defense, which, by the way, is never free, you must live in a staggering level of poverty. Yet we do little to address these issues once someone is in the system. In fact, we do a lot to exacerbate the very problems. Prison is warehousing with trauma. With too few exceptions, meaningful education and treatment opportunities, they're non-existent. People leave lockup saddled with criminal records, making second chances, or indeed even firsts, exceedingly rare. To put it bluntly, people enter the system already deeply disadvantaged, are chewed up, and then spat out even more so. Now understand that those disparities start early. For example, black youth as young as 5 are suspended and their actions criminalized at far higher rates than their white classmates for engaging in the same behavior. And note that kids these days are growing up in the data age where a scarlet letter is stamped upon the ether that no amount of scrubbing can clean. Futures are being foreclosed before brains are even fully developed. Now, out of the juvenile world and back into the world of adults. According to the National Employment Law Project, 1 in 4 people in the United States has a criminal record. According to the Bureau of Justice statistics, that number may be closer to 1 in 3, and those waters just keep rising. Now, criminal records are no minor matter. They influence nearly every part of life, from employment, as we know. A Society for Human Resources Management study suggested that somewhere between 87 and 92% of employers conduct criminal history checks on job applicants. Now, that's not the problem. Just conducting the check alone isn't necessarily the issue, and Kevin's going to talk a little bit more about that. The problem comes with how we're engaging those records, how we're receiving those records, what we're doing with those records once we do have our hands on them. And unfortunately, many employers reading records, many of the employment decisions after reading those records result in disqualifications regardless of recency of offense, regardless of severity of offense, regardless of the relevance of the offense or alleged offense to the job at hand, and that is a problem. Criminal records also affect the ability for one to find housing, professional licensure, access to public benefits, education, immigration. Both the ability to stay in the United States and petition family to join can be affected by the presence of a criminal record. The ability to travel can be affected, and the ability to cast a ballot, to have your voice heard, to have a political voice in your own backyard can be affected by the presence of a criminal record. And these are just a few of the myriad consequences that attach. There's medical treatment refusal based on records, a blockade to adoption, public office, jury duty, loans, and more. This is death by 1,000 cuts, or where a pound of flesh is no longer enough. It's as if, in this country, we believe that the only appropriate consequences are those that eviscerate a person, his or her family, and future too. Now, criminal histories affect nearly every aspect of who we are and how we engage with the world, from social to psychological, from personal to professional. We are confined and defined by our criminal past, but not for everyone. Really, just for a few of us, just 1 in 4 of us. The other 75, we've had the opportunity to skate through life unscathed by that particular reminder of that past act or acts. So here's what happened. In 2012, I sent out a flyer through our social service network at the nonprofit where I was working, stating quite simply, "We are all criminals. What have you had the luxury to forget?" I included my contact information and quite honestly didn't expect to get a call back. You may imagine my surprise when the phone actually started to ring. So I bought a camera and a recorder, and I hopped in my hatchback and drove all across the state of Minnesota and now all across the United States, interviewing people in cars and in bars, in diners, and quintessentially Minnesotan, on boats, anywhere where someone might feel comfortable enough to disclose to me something that they've otherwise never had to explain. You can find the first 100 or so of the more than 300 stories I've collected on the website at weareallcriminals.org. Should you go on there, and I encourage you to, check it out. When you do, you'll notice that if you click once on any one of the participants' pics, you'll see how they're introduced into the world as a doctor, as a lawyer, as an educator, a policymaker, as an employer. But after that title, you'll see how they would be defined in the world had they been caught: theft, sale of controlled substances, assault, driving while intoxicated. Click twice and you go into the story itself. Now, as I said, these range in severity, from quite serious, like this student and his aggravated robbery, or this pastor who, I kid you not, brought a loaded gun on an international flight. They took her off the plane, put her up in a hotel, and sent her home afterwards. There was no law enforcement involved. To the relatively innocuous, like this gentleman who carried a beer from one house party to the next, that's the open bottle, failed to return a library book. That is an offense, by the way, so check your bedside table. It's a petty theft, quite honestly. The next one down was public urination. This gentleman now has a contract to work with the Department of Defense, some of the highest security clearance in the nation. Had he been caught, he would find difficulty getting a job at a gas station. I know, because many of my clients were denied those very jobs for these very records. Take this woman who, as a young teen, shoplifted bangles and LPs to cope with the loss of her mother. She's now a recognized leader in her community. Likewise, the responses to the recollections of past transgressions are also varied. Like this gentleman, he told me about a time he had taken his uncle's hunting rifle out to college with him. Just catch a deer with it, his uncle said. Well, he didn't catch that, but he did decide to liberate the quarters within a double-posted parking meter. One drunken shot went right through that locking mechanism, letting loose nearly $40 worth of quarters. He calls it his $40 shot, and he laughed throughout the entire interview. Or take this woman who told me about a time as a teen when she would break into her neighbors' homes, eat their ice cream, rifle through their junk drawers, and occasionally swipe some silver. She laughed, pleading, "Just don't tell my son." She's now a chief financial officer. Some people note not just the luxury to forget, but the luxury of not regretting, while others recognize their privilege. Some are deeply sorry. Like this woman who told me about a time when she was working as a barista, she felt herself to be underpaid and underappreciated, so she would pad her tips with bills from the till. A $1 bill here, a $5 bill there, a 10 or 20. As she told me this, the tears streamed down her face. "I cannot imagine what life would be like now," she said, "had I been labeled a thief then." I'm actually going to skip that one. You'll never know what was behind the porta potty. I'm going to skip that story for right now. But time and again, I heard from people who recognized that life is, or that crime is an event in a life course, not a static characteristic of one's being. "I am not what I have done," she said. "I am what I choose to become." And that's a lot easier without a criminal record. This teacher said, experimenting with delinquency is normal and so is giving it up. I have that story, he said. Everybody has that story. If you find someone who claims they've never committed a crime, either they're lying, they have a poor memory, or they're very abnormal. I've heard from law enforcement officers who reflect upon the weight of the mistakes that they've made, and from salespeople who could have been known by their mugshots rather than their merit if their battles with addiction had been criminalized. Although not everyone recalls their past quite so quickly, like the gentleman for whom I took this photograph. So when I drew up that flyer that said, again, quite simply, we are all criminals, what have you had the luxury to forget, I sent that on to our social service network through that nonprofit. But here's what's key. I didn't ask our network to keep that, to sit on it, but rather to send it out to their networks, to their coffee clubs, to their book clubs, to their college campuses, their religious organizations, so that I could interview people who were 3, 4, 5 times removed from me. When the flyer landed in the hands of the gentleman for whom I took this photograph, it had to have been about 6 times removed. He had no context for the broader conversation of criminal justice reform, much less the more narrow conversation about our common criminality. He said that when he got that flyer, he was ticked off. He couldn't believe that there was some punk in the cities calling him a criminal just because he was a member of the human race. He said that for the first 3 weeks he would pick up his phone and dial all but my last digit, wanting to call me up and ream me out. When he finally did punch that last number, it wasn't to complain, but to participate. You see, he recalled that he used to run drugs across Lake Superior. Friends, how do you forget something like that? You forget something like that when you think of drug trafficking as something that happens between strangers in darkened alleyways, not something that happens between college friends. Here's what happened. His freshman year, this gentleman left his hometown, traveled across the lake, and went to a small private school. Sophomore year, he transferred back home and moved in with some of his old high school friends, who it turns out were no longer just smoking dope, now they were selling it. And he was the ideal conduit to the untapped market across those stormy waters, because he knew who the legitimate smokers were. He knew who the potential narcs were. So he said, and I quote, "They trained me in on the phones. I would occasionally take the drugs, sometimes take the money, but I only did it for a couple of years," he said. Really? Do you think that anything I did rose to the level of something criminal? Yes. State, federal, felonious, yes. And with that, this gentleman became one of my favorite participants. Because with that, this gentleman took it upon himself to start to unravel his own life. He wound back. He said, wait a minute, had I been caught, I wouldn't have graduated college. If I wouldn't have graduated college, I wouldn't have met my wife. I wouldn't have had that first internship where I met my wife. If I wouldn't have met my wife, I wouldn't now have my 2 sons. Okay, let's say that by some cosmic confluence, I still did meet my wife. I still did have my 2 sons. He said, what kind of father would I be? You see, every year this gentleman receives in the mail an application to coach his son's hockey league teams. And every year it asks the question, have you ever been convicted of, and lists 10 offenses. And every year he blithely checks, no. If, he said, they were to instead ask, have you ever committed any of the following, he doesn't know what he would do. What would he say? Or, had he been caught? My goodness, he doesn't know how he would proceed. He said he would have 3 options. Option number 1, he could check no. He could lie. So let's be real. This is a gentleman that nearly got an ulcer from a flyer. Dude's not about to lie. That's off the table. Number 2, he could check yes, we'll explain. Now, this gentleman had owned a business, and for the past 12 years, on his job application form, he asked applicants to disclose whether or not they had a criminal record, and any time that box was checked in the affirmative, even if there was an explanation afterwards, that app would end up in the trash because, he said, I didn't want to work with a criminal. He said that even if I were to check yes, and even if I were to explain, I know how parents are. And that stigma wouldn't just attach to me, it would run down to my boys, and there is nothing I would do to harm my sons. So that's off the table. Option number 3 said that's the only one left. I could just not respond. I could just take myself out. I can't tell you how many people I've worked with over the years who have just stopped responding, because you can only take that door slammed in your face so many times before you've just had enough. Now, make no mistake, I'm not saying that individuals with criminal records can't be outstanding fathers. They most definitely can. Mothers, sisters, leaders, believers, and more. What I am saying is that for the 75% of us who do not have a publicly accessible criminal record, sometimes we create these policies and practices that lock out of life the 25% who do, and sometimes we don't even realize we're doing it. I will happily report that this gentleman, after generously disclosing his criminal history to me and after working on creating this record and this story with me, he removed the criminal records application, or the criminal records inquiry from his job application. I've heard so many stories of people engaging in drug-related activity on college campuses, like this gentleman who donated part of his FAFSA funds to help finance a drug ring. He said he wanted a girlfriend. Or this woman who sold weed to frat bros and football players so that she could get a hey, what's up in the hallway. She said she was sick of feeling invisible. We'll skip to this one. I've heard some truly heartbreaking stories as well, like the gentleman for whom I took this photograph. At 15, he struggled to survive. He soon found that joining a gang offered him a chance at actually getting to school and getting back home without getting beaten up. But that didn't come for free. One Saturday morning, he was told that if he didn't pick up the lead pipe and hit a child, a kid that looked a lot like him, a member of a rival gang, another 15-year-old, he'd be the one beaten. He said he made the decision that day that he's regretted every day since. In fact, not a month goes by where he doesn't wake up at least once in the middle of the night screaming, thinking that it's all happening again. He picked up that pipe and he hit that child. The boy was eventually dragged away. Had this gentleman been caught, he would have been charged with first-degree assault for the benefit of a gang. He would have been certified to stand trial as an adult. At trial, he would have been convicted. Once convicted, he would have entered the system, and likely that vicious cycle of going into prison and coming out, going in and coming out. He wasn't charged. He graduated from high school, got a scholarship to go to college. There he said he was able to read an entire paragraph, to complete a math problem. For the first time, he was able to concentrate. He wasn't constantly looking over his shoulder to see what was coming next. He was safe. His grades skyrocketed. He went on to graduate school and now has a PhD in biophysics. Consider, again, the waste in this state and beyond when we're foreclosing futures before brains are fully developed. We are all criminals. It's about the human cost of mistakes. It's about the human cost of messing up. It's about the human cost of not allowing people to move on and never allowing them to come up for air. We have all, each and every one of us, violated the law. Perhaps it's been small, perhaps it's been large, perhaps it was decades ago, maybe it was last night, perhaps it was once or maybe repeatedly. But if you have any grasp of just how broad our criminal code is, you would understand how next to impossible or truly impossible it is to navigate this legal landscape for any appreciable amount of time without constantly violating the law. But you know what? Those mistakes, those violations, it's not all of who we are. We are also, quite simply, all human. And some of us, perhaps 1 in 4 of us, may be in need of a second chance. But make no mistake, this project is also a commentary on the disparate impact of our nation's policies, policing, and prosecution. Many, not all, but many of the participants have benefited from belonging to a class and race that is not overrepresented in our criminal justice system. And some of the participants have been pretty straight up about that. As a teenager, he fashioned himself to be the next Steven Spielberg. One day, he and his friends decided to direct and star in a mock-up of Dirty Harry. They dressed up as bank robbers, I kid you not, with replica firearms, briefcases stuffed with stacks of fake cash, and nylons pulled down over their heads. The camera was set up on the back of the car, the venue was an alley, and the backdrop was a bank. An open for business, middle of the day, bustling with bodies bank. Within minutes, they were surrounded by squads. "Drop your weapons." One of the guys refused to put his fake gun down, not fully comprehending what was happening. The police officers continued to shout until they all complied. Afterwards, this participant said, "They lectured us energetically till they ran out of words and let us go. They even let us finish the shoot." "I grew up in a very affluent town," he said. "It was the kind of place where it was easy not to have contact with police. The few interactions I had were very respectful and innocuous. A tap on the shoulder, a suggestion to go home." Not everyone is afforded that same presumption of innocence. For some, in particular, Black and brown and Native individuals, they are seen as always already criminal. Keep in mind that this isn't just about people who have lost their lives, right? Today we're gathered to talk about employment. Consider, too, those who were followed, accused, arrested, and abused, chewed up and spat out as if they weren't somebody's son, somebody's daughter, sister, brother, mentor, leader, somebody. So while you're thinking about the stories of people who got away with it, consider the lives, the narratives of the people who are serving time right now, people who are suffering under the weight of a criminal record right now, many for engaging in same or similar offenses. There are, after all, millions to choose from. Take note of the wasted potential. We need to invest rather than incarcerate. Our criminal justice system is teeming with scholars and students and artists, counselors and caretakers, change makers, game changers, leaders, and more. "I know who I am," he said. "I am not my mistake." Here's what I hope in all of this. I hope that you see a bit of yourself in this. I think that as we begin the conversation about hiring individuals with criminal records, it is so important that you recognize your own criminal past and then through that recognize your own privilege. I hope that you see some of yourself in these photos and the stories. I hope that in the reflection of that you take note of the context that you've allowed yourself. I was young, I was drunk, I was stupid, I was in a bad relationship, it wasn't my idea, I gave it back anyway, no one got hurt. Whatever that context is, recognize that it may have existed for someone who was caught or accused as well. Now, it may not be an excuse, but it is an opportunity to recognize a common humanity. I hope that some recognize the privilege that you've experienced and appreciate that not everyone has benefited from that same privilege. I hope that you can reflect upon how very patently different your own life would be had you been burdened by a record, and consider those foreclosed futures of all who have been caught. Finally, I hope that this project inspires you to take action. If the criminal justice system were designed by people who believe they might one day be involved, he said, or I would add people who have been involved, then we would have justice. So I ask you, what's your story? What would your chalkboard say? What would life be like for you if you had to check yes? A criminology professor in Georgia, Denise Woodall is her name, has been asking students about how people in prison or those with criminal records should be treated. How many meals should people in prison receive? Should they be allowed to study behind bars, to work after release, to live near you? After recording these answers, Professor Woodall asked students to recall their own criminal histories, acts that went uncaught, and consider what life would be like had they been prosecuted, punished, and labeled a criminal. And then she returns to those first questions once more. Professor Woodall tells me, for example, that more than 50% of the time, students who at first said that people in prison should receive no more than 2 meals a day bumped their answers up to 3 upon realizing that they could be the ones denied dinner for the next 8 years. We Are All Criminals seeks to close not only an empathy chasm, but an opportunity chasm. Consider this. What would life be like for you if you had to check yes? Here's another question. Do you deserve a second chance? If yes, Please explain. This is a call for reason, for equity and mercy, and acknowledged ownership in the problem as well as the solution, so that soon, when Anthony, that's him there, opens a sheet of paper, a page that's used to define his character, he finds not thief, but father, caregiver, nurse, speaker of multiple languages, volunteer coach, and avid reader. A man not defined by his worst moment, but by his true worth, with the luxury to forget and the opportunity to be forgiven. A man not tethered to his past, but wholly able to live in the present and to dream of a future. Thank you. Okay, and now I will introduce Commissioner Kevin Lindsey.
Emily, thanks. Great presentation as always. I think we have now partnered on this roadshow about 20 times, and I am always amazed at how powerfully you're able to deliver the story and really touch and give the audience something to think about. So thank you again for what you are doing here and providing second chance opportunities for folks. For this portion of the presentation, here is the roadmap that we're going to follow. I will attempt to answer questions during the course of the presentation. I will, at the end of the presentation, attempt to go through all the questions that have been sent. If you think of a question about 20 minutes after we get done today, don't worry. You can send that question to us at the department by calling us at 651-539-1100 or by sending us an email at info.mdhr@state.mn.us. Collateral consequences. Emily touched upon it, but just again, a refresher here. Collateral consequences are legal and regulatory sanctions and restrictions that limit or prohibit people with criminal records from accessing employment, occupational licensing, housing, voting, education, and other opportunities. Some collateral consequences serve a legitimate public safety or regulatory function, such as keeping firearms out of the hands of people convicted of domestic violence offenses, prohibiting people convicted of abuse from working with children or the elderly, or barring people convicted of fraud from positions of public trust. Other collateral consequences are directly related to the particular crime, such as registration requirements for sex offenders, driver's license restrictions for people convicted of serious traffic offenses, or debarment of people convicted of fraud. However, many collateral consequences apply to people convicted of any crime without any regard to any relationship between the crime and the opportunity being restricted, and frequently without consideration of how long ago the crime occurred or the person's rehabilitation efforts since that time. Collateral consequence with overbroad restrictions that offer no chance to overcome the restriction function as an additional punishment and may discourage rehabilitation and ultimately increase recidivism. While collateral consequences have been a familiar feature of the American justice system since colonial times, they have become more pervasive and more problematic in the past 20 years. Now, I submit they are that way for three reasons. One, they are much more numerous and impactful. Two, they affect more people. And three, they are harder to avoid and to mitigate. As a result, millions of Americans today are consigned to a kind of permanent legal limbo because of the crime they have committed in the past. In recognition of the ever-growing increase in collateral consequences and number of people affected, the Court Security Improvement Act of 2007 directed the National Institute of Justice to collect and analyze the collateral consequences of each jurisdiction in the United States. In 2012, the ABA, or the American Bar Association, Criminal Justice Section began working to identify and publicize all collateral consequences within the National Inventory of Collateral Consequences of Conviction. This is a publicly searchable website. In 2017, the Council on State Government Justice Center took over administration of the site, and they've continued to process the updating of these collateral consequences. As of yesterday, the Justice Center website identified, and we're just talking about Minnesota, 568 collateral consequences in the state of Minnesota. Most research indicates that the majority of employers conduct criminal history background inquiries prior to hiring an individual. Emily noted the SHRM, or the Society of Human Resource Management study in 2010 found that 92% of employers conducted some criminal history background inquiry prior to hiring an individual. There was a subsequent study by SHRM, again the Society of Human Resource Management, again which Emily mentioned, a couple years after that, which identified 87%. I think within the range, this is consistent to what we're finding here at the Department of Human Rights. During the auditing process of contractors, we found that 74% of our contractors conducted some form of criminal history background. Another economic study for you, the economic impact to society in limiting employment opportunities for individuals with a criminal history background. According to the economists at the Center for Economic Policy Research, Sherry Buckner and Alan Barber, in 2014, they estimated that the individuals who had been convicted of a felony, and they used an approximation between 14 and 15.8 million, they calculated that limiting the employment opportunities just for those individuals with a felony conviction was somewhere between $78 and $87 billion. The use of criminal history background inquiries has a disproportionate impact on limiting employment for people of color. The seminal study in this area was conducted by prominent researcher Deva Pager, professor of sociology and public policy now at Harvard University. In the study, she studied the employer's treatment of job applicants in Milwaukee, Wisconsin. In the study, she focused on the likelihood that an applicant would be called back for a job interview. And the 350 entry-level jobs in which they had sent the resume to, the criminal conviction was possession of a substance, cocaine, in which the individual was not suggesting to be a dealer, but just simply to have possessed the cocaine. And the disposition was that they did not serve actual jail time, that they had gotten probation. So with that, the 350 applicants being sent out, not surprisingly, within the study, whites without a criminal record were nearly 7 times more likely to be invited back than blacks with a criminal record. Most striking, however, was that the study found that only 14% of blacks without a criminal record were called for an interview, whereas 17% of the whites with a criminal record were asked to interview. Professor Pager's research results have since been replicated multiple times by academic researchers. So to this extent, when we talk about disparities in employment, what is it a position that the Department of Human Rights can look at in trying to address disparities which exist concerning the use by employers of criminal history information? They really fall into 4 buckets. The first is enforcing ban the box. It's a euphemism. The specific statute is referred to as the Criminal Rehabilitation Offenders Act within Minnesota. And that's making sure that private employers wait to ask for criminal history information until a conditional job offer has been extended or the applicant has been given an opportunity to explain the information which was found during a criminal history background check. Also, under the Minnesota Human Rights Act, people of the department are working toward ensuring that if employers decide to use criminal history information, that the application of those policies do not result in discrimination. And that's enforcing the provisions for employment discrimination under the Minnesota Human Rights Act. And in that area, the department can seek monetary damages or changes to policies if we find that there has been a violation of the Act. The third area for the department is under the Minnesota Administrative Rules, and for the department, those can be found in 5,3400 to 5,3600. And specifically, what those rules indicate is that the department can examine the human resource practices of state contractors. And within 3570, it refers to individuals hard to employ euphemistically for individuals with a criminal record. So in that space, the department is auditing the practices of all state contractors to ensure that they are compliant with the law. Finally, the department, through its duties of education under the Act, Minnesota Human Rights Act, can seek to change public policy that is codified in statutes and administrative rules that impose collateral consequences on individuals. So with that list, let's go back to ban the box. I kind of think of this as just sort of opening the door. And the language that you see here on the webinar is the language from the statute. So private employers are prohibited under ban the box from obtaining or requiring applicants to disclose a criminal record or criminal history unless they are permitted to ask for such information under federal or state law. While the law is commonly referred to as ban the box in reference to the elimination of a question on a paper application from asking applicants if they've committed a crime, the actual language of the statute is far broader and eliminates any means by which an employer seeks to obtain criminal background information. Employers who violate the law may be subject to a fine between $100 and $2,000 depending on the size of the employer. It's important to note that ban the box does not preempt federal or state law. So what do I mean by that? The ban the box law then yields to federal or state law. So for example, federal law requires commercial motor vehicle operators to ask job applicants to identify, and this is a specific language within the administrative rule, a list of all violations of motor vehicle laws or ordinance other than violations involving only parking, of which the applicant was convicted or forfeited bond or collateral during the 3 years preceding the date the application is submitted. So that specific language is found within the Code of Federal Regulations. Because that is federal law, the state law of ban the box yields to that, so an employer is permitted to ask that question. Now, please note that the department is going to narrowly construe, however, the statutory duty language consistent with the goal of the law of ban the box and criminal rehabilitation. So accordingly, a commercial motor vehicle operator may not ask job applicants to identify all convictions that occurred within the past 3 years. Again, if we take a look at the Code of Federal Regulations, it just talks about violations of motor vehicle laws or ordinances. So a question inquiring whether someone has committed another crime in another area not involving driving a vehicle would be an inappropriate question. Another example of narrow construction by the department concerns, and I'll use the example of private detectives. And by that I mean, Minnesota law provides that private detective agencies are required to obtain a full set of fingerprints and an employee consent form from all job applicants. The information is then collected from these applicants. It's then forwarded to the Minnesota Bureau of Criminal Apprehension, or known as the BCA, and the BCA then conducts a criminal background check. The BCA then denies or issues a license to the job applicant. The department has interpreted the above and similar legislative schemes not to create an exemption for employers. And I'll give you the rationale for that. First, the language only requires employers to facilitate the collection of information and not to themselves conduct a criminal background check. Second, allowing employers to reject a job applicant before the BCA makes its determination is inconsistent with the legislative scheme that empowers the BCA to deny or issue a license. So again, if the statutory frame in which you're operating on calls upon you to collect information which you're then forwarding either to a state agency or to a federal agency, and that state or federal agency is then going to pass on the applicant, you are not exempt under ban the box. Here are some of the most common questions that we have received from the department concerning ban the box. The first question, can an employer inform a job applicant that after interview, but prior to hire, they will be subject to a criminal background check? So the answer is yes. An employer may state in its pre-hire materials that all job applicants will be subject to a criminal background check. The second question, can an employer continue to use a multi-state employment application if they indicate online that job applicants applying for employment in Minnesota do not have to disclose criminal history information? So the answer is yes, It is a best practice for the employer on the online application to preclude the job applicant from being able to answer the question. So let's be very clear on this. If the instructions online just simply say that the Minnesota applicant does not need to answer the question, but it does then allow individuals to answer the question, the department is going to assume that you have not really complied with ban the box, because the job applicants can't answer that question. And we're going to assume that you did review that information and consider that to be a violation of the law. Can an employer refuse to extend a job offer to a candidate solely on the basis of the information shared by the applicant during the interview about their conviction? So again, yes, the law does not require, ban the box does not require the employer to extend a job offer. Employers should ensure, however, that their decisions on when they extend job offers are not influenced on the basis of one of the protected classes within federal and state anti-discrimination laws, and we'll talk about that in a minute here. But the bottom line is that employer can use information about criminal history in making a decision as to when to or who to hire in the process. Can an employer refuse to interview a candidate upon reviewing the candidate's criminal history background information if the decision was made after the candidate's application was screened and the candidate was placed in the pool of candidates to interview, but then never interviewed the candidate? So the answer here is no. The fact that you have documented that you have screened candidates and put folks into an interview pool, but then not allowed the individual to actually be interviewed, was not compliant with ban the box. And Emily had said something earlier within her presentation, which I think is very important in this space. When testimony was being introduced before the Minnesota legislature concerning the ban the box, there was information submitted to the legislature concerning the Department of Justice efforts on providing information which is then harvested by companies which provide information to employers about criminal history. And not surprisingly, the Department of Justice had indicated that there are sometimes data entry errors by police officers. Sometimes the individuals who were arrested, surprisingly, didn't always give accurate information. And then there were also disposition issues. So sometimes someone would be arrested and a case may go on for a year or 2 years and no one would circle back to actually see if the individual was convicted. So it was clearly the intent of the legislature to facilitate a conversation to ensure such errors were discovered during the hiring process of the interview. So for the department, we believe that the interpretation of the statute really requires an interview to be conducted. Now, that doesn't mean that the employer, again, has to hire that candidate, but you at least have to go through the process of the interview. Going back to what I had said about ensuring that the decisions which are being made do not suggest discrimination has occurred in the decisions you make as to who you hire. So, employers who allow hiring managers to use criminal history information should make sure that the decisions are made in a consistent manner. Failure to make decisions in a consistent manner may result in a finding for the department of what we consider disparate treatment. So disparate treatment may occur on the basis of race when an employer treats an African-American candidate less favorably to a white candidate with similar education, background, skills, and work experience. So, for example, if an employer would consider a marijuana possession conviction in high school as a youthful indiscretion that does not define one candidate, then the employer should afford the same discretion and hire the African-American candidate. Disparate treatment may also occur on the basis of national origin. So, for example, when an employer treats a Latino candidate less favorably to a white candidate with similar work experience, in a situation such as that an employer would not withdraw a conditional job offer for a conviction that occurred more than 5 years ago for a white candidate, the employer should afford the same discretion and hire the Latino candidate. I want to bring to employers' attention a case from the United States Supreme Court called Connecticut versus Teal, and I just want to bring it for this one purpose here, is that in Connecticut versus Teal, the United States Supreme Court held that a bottom line racial balance in the workforce does not preclude employees from establishing discrimination. So the fact that the workforce itself has some evidence of being racially and ethnically diverse does not necessarily mean that someone would not be successful in arguing to the department or to a court that discrimination is occurring by the way in which the employer is using criminal history information. The safe harbor, compliance with Minnesota's ban the box law does not equate with compliance with federal or state anti-discrimination laws and the application of criminal background checks. Also, an employer that is exempt under ban the box is still subject to the jurisdiction of the Equal Employment Opportunity Commission and the Minnesota Department of Human Rights. So again, you can be compliant with ban the box law in the process of how you use criminal history information. That can result in a violation of the law. So let me make this clear through an example. Let's say that you do not ask for any criminal history information. After you have interviewed all of the candidates, you then ask for information considering whether they have been arrested. And you find out information about arrests. Arrest in our country is you are presumed innocent until found guilty, so an arrest is not sufficient to suggest that an individual committed a criminal act. And Emily has already educated us earlier today about the great disproportionality which exists concerning arrest records for various racial and ethnic groups. So to the extent that the employer is excluding candidates on the basis of arrest alone, that could have a disparate impact on racial and ethnic communities, which would then be a violation of law. So you could have complied with ban the box and waiting to ask the question until after everybody's been interviewed, but your process about what kind of criminal history information you use and analyze to determine on who to hire could be a violation of the law. To help employers in this space on what would be a proper way in which to use criminal history information, I would give you Green versus Missouri Pacific Railroad, which is a case here out of the 8th Circuit. There's 3 elements which are listed there on the screen for you. But for me, the bottom line of this case is that the employers need to demonstrate that using criminal history information is, quote, job-related and consistent with business necessity. Job-related and consistent with business necessity. And the 3 touchstones for Green versus Missouri, again, listed here on the screen. I want to give you 2 other references. The first is the Uniform Guidelines on Employee Selection Procedures, which helps employers walk through the process of determining criminal history information to be used in determining when to hire a candidate. And the other material that I'd like to give to you is the EEOC guidance on using criminal history information, which was published on April 25th, 2012. So the department, through its efforts, audits the hiring practices of state contractors and then contractors that do work for our favorite metropolitan agencies, such as the Metropolitan Airports Commission, Sports Facility Authority, Metropolitan Council, and everybody's favorite in Minnesota, the Metropolitan Mosquito Control Commission. That tells you when you live in Minnesota, we're worried about mosquitoes. So employers, if you're thinking about what are sort of best practices, here's what we're talking and saying to contractors as to best practices. So let's first start with ban the box. Employers should review their employment application to ensure that none of the questions on the application could be construed to require a job applicant to disclose criminal history information. Employers should pay particular attention to questions on the application that ask the applicant to explain an answer. Requiring applicants to explain an answer may force them to divulge criminal history information. Employers should also review that all material that they provide to applicants during the hiring process is not limited to the employer's job application. Again, any information that arguably suggests that an individual needs to disclose criminal history information in answering question and any of its pre-hire materials should be removed or amended to comply with the law. If an employer believes that they are required under federal and state law to request criminal background history information from job applicants, they should carefully review the statute. An erroneous good faith violation of the statute is not a defense to ban the box. So again, make sure, are you actually required to ask the question? Does the statute or the rule compel you to ask the question? Or does the statute or rule just ask for you to collect information from the job applicant? If the statute requires the employer to ask all job applicants specific questions on its application or within its pre-hire materials, the employer should ensure that the questions asked of applicants aligns with the language of the statute. Again, as a reminder, the department narrowly construes statutory exemptions. So if the language within the rule identifies a specific language that you are supposed to use, the department is going to ensure that you are using the exact language which is set forth within the federal statute or the federal administrative rule. A couple of tips for employers if they decide to use criminal history background information in making hiring decisions. Again, uniform guidelines on employee selection procedures or the EEOC guidance from April 25, 2012 is a good place to start on developing the targeted screening process. Second, there should be a clear written policy on how the employer determines when to hire a person with a criminal history background. The policy at a minimum should address how the company weighs the nature and gravity of the offense, the length of time since the act was committed, and the nature of the job sought. And again, that's similar to the Green versus Missouri factors. Hiring managers should be trained on how to evaluate evidence of rehabilitation and mitigating factors during the hiring process. A decision not to hire should not be based solely on the fact that the candidate was arrested. In Minnesota in 2010, the EEOC settled a case with PepsiCo in which PepsiCo here locally disqualified 400 African-American candidates from going forward, and the EEOC settled that case for $3.13 million. And that was, again, where PepsiCo was excluding candidates solely on the basis of those candidates indicating that they had been arrested. The fourth tip, hiring process should provide all job applicants with an opportunity to explain to the hiring manager why the criminal history information is inaccurate or why the applicant should not be excluded as a candidate for the position. Fifth, the employer should periodically review and analyze the hiring decisions made by hiring managers to ensure that reviewing criminal history information is occurring consistent with the employer's policy and implicit bias is not occurring when hiring decisions are made. And for the department, I think for contractors, what we're finding is that the contractors that are most successful in creating inclusive practices and policies are the ones that are consistently improving and being committed to examining how well they're doing in their hiring practices. So that's no different in this space. I see where we are with time. I will touch quickly here on these last three slides. Minnesotans lose the right to vote until they have been released from supervision. So that means including while they're living in the community, even if they've never spent any time in prison or only served a short jail sentence. In 2011, of the 63,000 Minnesotans who were unable to vote due to a past criminal conviction, only about 16,000 were behind bars in prison or in jail. In other words, 75% of those being denied the right to vote under Minnesota law are living in the community, working to earn a wage to support their family, and they are paying taxes. You can find out more on that last slide. There's a link to a YouTube video on the department's website. The department sits on an interagency task force ending homelessness. Homelessness contributes to a higher risk of incarceration, and incarceration contributes to a higher risk of homelessness. The National Healthcare for the Homeless Council notes that in 2008 that approximately 15% of jail inmates had been homeless in the year prior to incarceration, and 54% of individuals who were currently homeless at the time of the inquiry had been incarcerated at some point in time during their life. In addition, those experiencing homelessness are found often to be arrested more often, incarcerated for longer periods of time, and rearrested at higher rates than people with stable housing. So this is clearly a reason why this is one of the areas of focus in the ending homelessness space. The department is a member of the Governor's Cabinet on Diversity and Inclusion. In that space, we're working on civic engagement. There are more than 220 boards and commissions within the executive branch. If we are truly interested in a society and individuals being fully integrated back into society, we need to ensure that we remove any unnecessary barriers that prevent them from engaging in civic activities. Participating on boards and commissions beyond allows individuals to engage in civic engagement activities and allows them to make connections with other people in society working toward a common purpose. Individuals are much less likely to recidivate if they have purpose and are working toward common goals with others. The proposal from the department that would prevent boards and commissions from asking or obtaining criminal history background information is one way in which we're moving to try and, again, ensure that people are integrated in society and that they're less likely to recidivate. So with that, I appreciate that we have gone a little beyond an hour here in our time, but as I said, it's hard when Emily gets going on the storytelling because the stories are so good, no one wants to slow her down. And I hate to, be the backup. I think I actually got her to laugh on that one. All right, so with that, we will take a minute here to see what questions have come in. But again, I want to thank everyone for being a part of this presentation, and again, appreciate Emily being part of it with us as well. So we have two questions, and then we're going to scan to see if we have others here. The first question that came in: an employer that hires teachers, they also hire office staff. Because they work with children, they understand that a background check is required. In their recruiting interviewing process, they give notice that they will conduct a background check. However, that notice that they are going to have all applicants undergo a background check is not listed on their application. Do they need to redo their application? So the answer is, from the department's perspective and looking at Ban the Box, we're looking at the entirety of the pre-hire materials. So if the hiring materials is just simply saying at some point in time you're going to do a background check, it does not necessarily have to be on the employment application. And what Ban the Box is primarily concerned about is, are you using criminal history information prior to actually interviewing the candidate? So in this case, pre-hire materials indicates that at some point in time during the hiring process you're going to have applicants conduct a background check. That's fine. You're consistent with Ban the Box because you're not asking the information until you've already decided to interview candidates. The second question I have here is, I've read studies that show that black-sounding names are discriminated against. What is Minnesota doing to monitor, prevent this type of discrimination? The study I believe that you're referencing came out of MIT, and I'm blanking on the title of it. I think it is Why is Jamil and Lakeisha Less Likely to Be Hired? Emily is the girl's name, but I cannot remember the male's name within that study. And this is about the same time in which the Pager study came out. So under the Human Rights Act, there are certain questions that if they're on the application, they are what we consider per se violations of the law. So for example, if the employment application was to ask, are you married? that would be an inappropriate question because marital status discrimination is a prohibited type of discrimination in the employment provision under the Human Rights Act. But just simply asking someone's name is not viewed as a prohibited act under the Minnesota Human Rights Act. We have had some informal conversations, so I would say we've kind of put on our education hat, and we have had conversations with employers. And there are some employers within the state of Minnesota which scrub the name and then have the decision made as to who is to be interviewed solely on the basis of the rest of the information in the employment application. So this is kind of an emerging area, but there is no prohibition under the law to say that you can't review the name or you're limited in reviewing the name. So another question has come in: can an employer outright deny a position solely because a person is on probation? So the question really is it consistent with business necessity under Green? So I hesitate to give you a blanket prescription to say that you could always not hire someone simply on the basis of probation. You're really looking to see, is the individual capable of doing the job, or are they most qualified to being able to do the job? A question of just simply being on probation in and of itself probably is not going to answer that question for you. And I see that there is some furious typing still going on, so I'll hold on for just a second.
Thank you for joining MnDHR and Commissioner Kevin Lindsey today. Thank you to our guest presenter, Emily Baxter. You will find more information on MnDHR's website, mn.gov/MnDHR. Remember to have your colleagues view this webinar on MnDHR's website. We will follow up with an email to registered attendees once it is ready to share. Thank you so much and have a great day.